today's discussion will generate more light than heat. Today's program reflects more than 6 months of planning, but we can also turn on a dime at the Levin Center. So at noontime next Wednesday, the Levin Center will present a forum on the GOP tax proposals, a look from all sides. We hope you will be able to join us then. Some people to thank as we begin. First of all, the Manoogian Simone's Foundation and Alex and Marie Manoogian Foundation for their support that helped make this program possible. Linda Gustitis. Is Linda in the room? Yes, she is now. Linda Gustitis is our Washington co-director, actually one of 2 Washington co-directors. Planning for this conference began some 6 months ago before I came on as director, and Linda was instrumental in not only getting this off the ground, but seeing the program to fruition. Kaylee Place, who takes care of media relations for us, has been instrumental in getting word out about what we're doing. Misbah al-Islam, the gentleman you saw here just before me, taking care of our IT needs. And many of you have met or heard from Emily Barr. Emily came on as program manager for the Levin Center in the middle of September. I don't know how we ever got along without her, but she is really the person who's been pulling all the logistics together for this program. One other logistical detail, we were surprised as you were to find that the closest men's room was being painted. For those of you in need, if you can just go right through this atrium, right through the vestibule, right through the west atrium on the other side, and then you'll see towards the left is another facility to help you out. We now can move from the mundane to the sublime, because it's my pleasure to be able to introduce the new Dean of Wayne State University Law School, Richard BIERSCHBACH. Dean BIERSCHBACH clerked for Sandra Day O'Connor, certainly a friend of Wayne Law. He has had a distinguished legal career in both the public and private sector. He comes here from Cardozo Law School, where he really showed what he could do not only in the classroom, but he is a highly regarded legal scholar as well. So allow me to be one of the many who've been welcoming you back to Michigan and to Wayne Law, Dean Richard BIERSCHBACH.
Thanks a lot, Bob, and thanks again for your efforts in bringing this group together. And wow, this is a really full house. This is fantastic. Thanks to you all for coming, and thanks especially to our panelists for being here. You know, events like this really get me excited. I love these gatherings of scholars to dig into these meaty legal issues, and I just want to echo Bob's remarks in thanking everybody involved who helped make this happen, and especially thanking the Manoogian Simone Foundation and the Alex and Marie Manoogian Foundation for their generous support to make this event possible. Wayne Law is really the proud home of the Levin Center, and I say that with the utmost sincerity. I think a lot of you probably know what the Levin Center does, but maybe not all of you do. So in case you don't, the center's core mission is to educate future attorneys and business leaders and the legislators and other public servants on their role in overseeing public and private institutions and using oversight as an instrument of change. And we've got staff both here in Detroit and on the ground in Washington, D.C. who are working every day to inspire and train a new generation to ensure that public and private institutions operate with integrity and transparency and accountability to the general public. And the work that they do really is unparalleled. As far as I know, this is the only national academic center that's actually dedicated to the art and practice of oversight specifically. And they're doing some amazing things. They hold bipartisan oversight boot camps, trainings in Washington, D.C. They've got online modules about the art and practice of oversight that are available to anybody who wants to take advantage of those. I think they've done some international trainings in the EU, maybe in the Ukraine, if I have that right. Linda's saying I do, to help other democracies understand how to use oversight to make their governance better. And so it's fantastic and interesting and cutting-edge work that they're doing, in my opinion. And it's work that, in my mind, is really consistent with the mission of this university and this law school. So this is a public law school, and of course all public law schools and public universities have a public service mission in some regard. But one of the things that I love about Wayne State Law School is that I think that mission is really baked into it in a deeper way than some places. A lot of you might not know about the history of Wayne State University. The university itself was founded in 1868 by a group of Civil War doctors who really were shocked at what they saw in the Civil War and wanted to found an educational institution that advanced the betterment of humanity. Their focus was doing it through medicine, but it really was founded for this very public regarding purpose. And the law school is now 90 years old, and since its very first class has graduated attorneys who went immediately into civil rights work. And so has long had, as I said, this sort of public service ethos baked into it, and also at the same time has grown. The university and the law school has grown to become really a premier research institution. The university is a Carnegie I research university at this point, but it still marries that with this public service and this access mission. And that's another way in which I think the topic of this symposium really resonates with what we do here. I have heard story after story in just the 3 months of my tenure as dean from graduates of this law school who have said it was my entry point into really a life-changing trajectory. You know, Wayne allowed me to get the kind of education I otherwise might not have been able to get, and these people then go on to give back. And many of them, in fact, are immigrants. And so it's kind of fitting that we should be talking about this topic at this law school today. Now I just want to take a minute to introduce the center's namesake, former U.S. Senator Carl Levin. So Senator Levin is Michigan's longest-serving U.S. Senator. He worked on behalf of the people of Michigan for 36 years. And in that time, he became one of the nation's most respected leaders on national security. He became a powerful voice for equality and justice. He became a fighter for economic fairness. All of those are obviously very impressive and important, but I think what's most striking is the respect he earned from colleagues on both sides of the aisle while doing all of this. And during his time in the Senate, he was the chair of the Permanent Subcommittee on Investigations of the Homeland Security and Governmental Affairs Committee. He also was the chair of the Senate Armed Services Committee. After he retired in 2015, he decided to make Wayne Law School his new professional home, and we are eternally grateful for that and for the example he sets for our students and the rest of us here. So please join me in welcoming the chair of the Levin Center at Wayne Law and our distinguished legislator in residence, Senator Carl Levin.
Dean, thank you so much. It's great having you at Wayne. You're a terrific addition to this law school and the university. Thank you also for saying that I was the longest serving senator in Michigan instead of the oldest senator that has ever served in Michigan. It's great to see you all here this morning. This is a really another exciting moment for the Levin Center. The Dean mentioned that some of the activities that we engage in other than this kind of forum, which has been a focus of ours, and that's the oversight effort, a bipartisan, in-depth oversight that we have focused on, which we are always very proud of as part of our Permanent Subcommittee on Investigations activity. always bipartisan, always in depth, always fact-based, always with staffs, Democratic and Republican staffs working together, looking very directly hard for facts, coming up with joint reports almost always, unlike some of the activities that you've read about in Washington from other committees that are highly partisan, particularly, frankly, in the House of Representatives. That permanent subcommittee under the great staff work that we had has really spread our message worldwide, as the Dean said. We have a couple other people that I want to focus on here this morning to introduce. I won't thank everybody that's already been thanked, but I do want to single out Eugene Dreiker. Eugene is kind of one of the great supporters of this university. He's the chair of our advisory board at the Levin Center. If you walk out, you'll see, I think, pictures of about 10 heroes and heroines of Wayne University that'll flash on the wall. That's one of the heroes right over there, Eugene Dreiker. The Levin Center would not really be here but for Eugene Dreiker. And if I can mention one other person and single her out, and that's Linda Gustitis, whose name has already been mentioned. Linda is one of the co-directors in Washington, but she has been really active in making it possible for the Levin Center to come into existence. She's a former staff director of mine, along with Elise Bean, who was the other co-director in Washington. So I want to single her out and Eugene out and ask them actually to stand, if they would. I'll add my thanks to the Manoogian Foundation. The Manoogians' special love of this country comes from their immigrant background. The old man, as we used to call him, Mr. Manoogian, as everybody said, Mr. Manoogian and his great wife were really a big part of this community. The Manoogian Mansion was donated actually to the city of Detroit by the Manoogians. A major interest of the, by the way, I ought to introduce my wife Barbara. She will hate this, but I'm going to do it anyway, unless she's already skipped out because she didn't want to be introduced. But she's here somewhere. So Barb, a major interest of the Levin Center is promoting good governance and the use of civil discourse. We have too little civil discourse in this country now. These are meaningful terms. Good governance is how we make policy decisions, the processes that we use, that we need to focus on, which is a commitment to the rule of law, commitment to facts, commitment to responsiveness, to inclusion, and to fairness. We've got to add to that list, perhaps should be nearer the top, is civility. We just have got to be able to express our passions very forthrightly and very strongly, but we've got to be able to do it in a way that we respect the views of others and that we listen to the views of others. We need dialogue. We've got to, we live in a time when facts are under assault. I'm not sure that I ever would see that time where people actually say there are alternative facts, where you read in the paper in the morning, the first column is what are the false facts that were spreading around the social media for the last few days. But that's where we're at. And that's more reason why we've got to listen. And we've got to listen and we've got to focus on what other people are saying, not just our own views, but on what other people are saying. We've got a viral social media which has increased the problem and the challenge to all of us to be able to separate or to at least attempt to determine what are the real facts. The environment in this country makes that a particular challenge because of the divisiveness, the divisions that exist in this country seem to push people almost automatically on one side or another of a fact. Well, we've got to find ways to overcome it. And one of the things that we're focusing on here at the Levin Center, and one of the reasons why these panels are an effort to hear from both sides, sometimes all sides of an issue, is that we can try to, at the same time we're diving in and digging in on some of the most difficult issues of our time, including immigration, that we can show that we can do it in a way that shows respect for the views of others. I'm not talking about views which are racist or views which are wild or views which are off the chart. I'm talking about views that people who have respectable views on subjects which differ from other views can be heard and listened to. There's an old saying, actually a practice at the Yale University Political Union. And that practice was that members are admired who are members of that union, particularly any member who could point to a time when a debate changed their mind on an issue. So the members that got kind of a special kudo were those that could stand up and say, I went to a debate thinking this, but that debate changed my mind. That produced great respect at that particular place. I don't have a hell of a lot of respect for Yale because I don't go there, but the political union, I think, had a wonderful idea. So let me close by expressing the hope that we will leave here today, and the belief that we will leave here today enlightened, not just about the challenges that face our country in the area of immigration, but that we will see that listening to this debate will be enhanced by the civil discourse which will be evidenced here today. So I want to thank you all for coming. Thank you for the great support of this university, which is part of a thriving city. It's a wonderful thing to see how this city is not only thriving, but that we have great institutions like Wayne that have kind of stayed the course, been an anchor for this city during some tough times, and are now part of a great rebound of the city of Detroit. Great to be with you. Thanks for coming.
Thank you so much. Thank you all for being here on a Friday morning. It's very impressive to have you all here, and welcome. I have the pleasure of introducing a really phenomenal panel this morning. And I'm going to tell you a little bit about our speakers, and then I'm going to let them speak, and we'll have plenty of time at the end for questions, so please do start thinking about your questions. Our first speaker this morning will be ROYCE Murray, who is on my left. She is currently the Policy Director at the American Immigration Council. She was the Director of Policy previously at the National Immigration Justice Center. She was also the Immigration and Human Rights Consultant at the National Immigration Forum, the Center for Global Development, and the World Bank's Nordic Trust Fund. She worked previously in the U.S. Citizenship and Immigration Services Office of the Chief Counsel in the Refugee and Asylum Law Division, and she was also an asylum officer with the INS. And as we determined last night at dinner, we were actually at Georgetown Law at the same time. So it's lovely to make a new acquaintance. Our next speaker will be ANIL KALHAN. I'm making sure I say that right. ANIL KALHAN, who is a professor at Drexel University, the Thomas Kline School of Law. He, however, is currently visiting at Washington University in St. Louis. He is the chair of the New York City Bar Association International Human Rights Committee. He is also a member of the New York City Bar Association section on immigration and nationality law and on the section on international law. He is the chair-elect of the American Association of Law Schools Immigration Law section. He is also the co-founder and former chair of the American Association of Law Schools section on law and South Asian Studies, and he's an affiliated member of the University of Pennsylvania South Asia Center, and many, many other things as well. But that's a brief overview. And our final speaker tonight, or this morning, will be Denise Gilman. She is a professor at the University of Texas Law School, where she directs the Immigration Law Clinic. She is also, she was the director at the Immigrant and Refugee Rights Project at the Washington Lawyers Committee for Civil Rights and Urban Affairs. She was a human rights specialist at the Inter-American Commission of Human Rights at the Organization of American States. And she was the director of the Mexico Project at the Lawyers Committee for Human Rights, which is now Human Rights First. She has also served several years on the ABA Commission on Immigration and the ABA section on Civil Rights and Social Justice. So as you can see, we have an incredibly experienced panel, and I will turn it over now to Royce. And let me find your PowerPoint.
Morning. Thank you for having me here today. It's really a pleasure. I rather like the brisk weather. It is my official introduction to winter, I guess, as it is for many of you too. It gets us going and awake in the morning today, which is great. So I'm here today to kick us off with a discussion about immigration detention. Some of you may be more familiar with the immigration detention system than others, but my job here this morning is to sort of level set, make sure we all have a common understanding of how the system operates, what it is, and then I will hand it over to Anil and Denise, who can get into some of the most interesting nuances and cutting-edge issues that are facing the immigration detention system today. I do want to begin by saying the immigration detention system is a civil detention system. And it's an important thing that I think gets easily overlooked. It can look a lot like jail, it can feel a lot like jail, and it can sometimes seem to serve the purposes of jail, but it is ultimately a civil matter. No one is serving a sentence in immigration detention. That's not the purpose. The purpose here is to maintain custody of someone while they're going through a removal proceeding or pending their deportation, because there's been an assessment that they're a flight risk, that they are a public safety risk, or that the law requires that they be detained. And Anil will get into this in further detail. But I do want to make that clear from the outset that this is a civil system that is wholly distinct from the criminal justice system, even though there are many, many similarities. Immigration detention is also not a partisan issue. Where in a time, as you were saying, Senator, where many things can, there isn't a lot of civil discourse around a lot of issues. I think immigration detention, much like many immigration issues, gets caught up in very political discussions. But immigration detention is a creature of both Democratic and Republican administrations. There are no purely good actors here in terms of one administration or another. Detaining many, releasing many, or doing it a right way. This has sort of been a universal in recent years. So what do I mean by immigration detention? A number of different government entities can detain immigrants. And we will focus here today on the detention that happens from the Immigration and Customs Enforcement Agency, otherwise known as ICE. But there are other agencies that do forms of immigration detention, so I want to note them so you know what we're not talking about today. Just quickly, Customs and Border Protection, which houses the Border Patrol and the customs agents who you'll see at ports of entry, at airports, the blue uniforms, the Border Patrol, the green uniforms. CBP does take people into custody when they apprehend them. They tend to be shorter terms of custody. It's usually supposed to be less than 72 hours, often much shorter than that. And they will often turn in those individuals, generally speaking, they turn them over to ICE custody. So ICE is when individuals are held either in the interior or for longer periods than those initial apprehensions. So that's, and there are hundreds of thousands of people who go through CBP custody, so I'm not trying to give it short shrift because it's quite important, and there's lots of studies and litigation, including what my own organization has done, on the conditions under which CBP holds individuals. But today we will focus on ICE detention. The other main form of custody that we won't talk about today, but is equally important to set aside, is unaccompanied minors. So immigrant children who are apprehended without a parent can be taken into the custody of the Office of Refugee Resettlement, which is part of the Department of Health and Human Services. So a wholly different entity than ICE and CBP, which are within the Department of Homeland Security. Those unaccompanied children are kept in more child-appropriate shelters with varying levels of security. But that shelter system is also distinct from what we're talking about, and that too holds thousands of people under the age of 18. When children who are in custody age out of those shelter custodies, they will end up in ICE detention, oftentimes. So those are different feeders, both the CBP custodial system as well as at times the unaccompanied children can feed into ICE detention. But I wanted to set that aside because ICE detention is focused on adults, both men and women, to be clear, and either individuals who are apprehended in the interior or who are referred to them from some border apprehension. As is noted above, there's a lot of numbers to talk about, so I wanted to put them on the screen because they can be, frankly, a little bit overwhelming. On an annual basis, we're talking about roughly 400,000 people who are kept in ICE detention for some period of time. That's a lot of people in a system that really doesn't get much attention. It doesn't get much thought, but they are passing through for varying lengths of time. Some for very short periods of time, some for much longer periods of time, months if not years. People can be kept in that custody. The average length of stay for an individual who's been picked up in the interior is 52 days, but that's an average. So there are people, I mean, we've had, in my previous capacities, we've had clients, and I know, I'm sure Denise has as well, and many of you in this room, some of you in this room may have as well, clients who've been in custody for years. So that's just an average. In fiscal year 2017, the ADP, the average detained population, the average daily population in detention was over 40,000 detainees. So that speaks to the fact that those beds are being turned over, but that we had 40,000 people in custody on any given day. That's important to be looked at in the context of history, because the immigration detention system, while I said that it's both a creature of Democratic and Republican administrations, this is not something that has existed for decades in these sorts of numbers. So prior to the 1980s, you had about 30 people detained a day. So this is a recent phenomenon. As of the mid-90s, we were looking at a few thousand beds. By 2001, 19,000 beds. And now, as I mentioned, we hover somewhere in the high 30,000s, around 40,000, it depends. Right now, we don't always have current numbers. We don't always get that kind of transparency from ICE, but it can hover between the mid-30,000s, depending on different variables. The administration does want to expand the immigration detention system to record numbers, given that history. There have been proposals earlier this year that they would like to ramp up the immigration detention system to 80,000 beds. So basically doubling the existing capacity and occupancy of the immigration detention system. That, of course, takes money and can't happen overnight. So even this past year, for this current fiscal year, the budget request was, they were basically looking in 10,000 bed increments. I think their idea was, if we're at roughly 40,000 now, every year for this administration, we can request an additional 10,000 beds. That doesn't mean Congress will fund it, but that's how the process is going so far. So they did request for this fiscal year just over 50,000 beds. One of the variables that has informed the number of beds we have is something known as the detention bed quota. Has also been called the bed mandate at times, more recently the bed quota. And basically, since 2009, Congress has required that ICE maintain a certain number of beds. And that means having them on hand to use as needed. The bed quota in recent years has been 34,000. And indeed, those were the number of beds available. That doesn't mean the bed quota does not require that those beds be filled. It really does just say they should maintain 34,000 beds. However, when you have a bunch of expensive beds laying around and you have to justify your budget, it goes without saying that there will be some desire to fill those beds, and it becomes a driver of the immigration enforcement system because those beds can't just all sit empty. And I think Denise will talk a bit more about how custody decisions are made about who remains detained and who gets released, and how that can get informed by bed occupancy rates and the bed quota. Another variable in terms of the number of beds and how they get filled are guaranteed minimums. So a lot of contracts will include requirements that basically contractors get paid for a certain number of beds regardless of whether they're filled. And there are at least 24 different detention facilities that have these guaranteed minimum provisions. Most of them are private detention facilities, but that includes it includes the family detention facilities that exist that I'll speak about in a moment. And since I did mention costs, I do want to just note here for a moment that we do spend over $2 billion a year on immigration detention. So this is not an inexpensive enterprise. The average bed costs vary. The estimates really do vary depending on whether you include ICE overhead costs or not. ICE has different estimates than other experts in the field have provided. The estimates range around $160 a day. They can go down to closer to $123 a day if you're not factoring in that overhead. And for family detention, it can be much more expensive. And here you can see just sort of a visual representation of how over time this daily population in immigration detention has skyrocketed. So this is a recent phenomenon to see these numbers be as high as they are. So there are different types of immigration detention facilities. There are over 200 detention facilities that ICE maintains around the country, and they are everywhere. There are different types of facilities. And I'd like to walk through them. There are service processing centers, also called SPCs, which are the ICE-owned facilities. They are the most expensive to operate, and there hasn't been an effort really in recent years to create more of them, basically I think for cost reasons. And I don't know that ICE actually wants to be in the business of owning and operating detention facilities. At least that's not, evidenced by the ways in which they have sought to expand. Rather, they have looked to private contractors to provide a lot of their beds, and those are the contract detention facilities, also called CDFs. And those are both privately owned and operated. And those are generally some of the biggest facilities, that have thousands of beds in one location. 65% of the immigration detention beds that we have are in these facilities, in these private prisons. GEO and CoreCivic, which was previously known as CCA, are the two biggest private prison companies who operate both in the criminal justice system as well as the immigration detention system. We talked about drivers in terms of the bed quota and minimum guarantees, or guaranteed minimums. But the private prison industry unquestionably has a role here in what the immigration detention system looks like. I will note that, there's extensive public reporting on campaign contributions by these two companies in particular, and I'll note that while there had been an effort under the last administration to reduce the use or expressed interest in reducing the use of private prisons, both in the criminal justice system, that course was reversed under this administration, and the stock doubled of GEO and CCA, or CoreCivic, between Election Day and February at the start of the administration, with a renewed interest in expanding the use of private detention beds. So in addition to SBCs and these CDFs, the other big bucket of immigration detention beds are intergovernmental service agreements. It's a big, fancy, ugly sounding name for county jails, the use of contracting with local facilities, IGSAs, to use some or all of the beds in a facility for the purposes of immigration detention. So they may have certain beds or a certain part of a jail that remains available for ICE to use for immigration detention purposes. That too, in addition to the contract detention facilities, is where we see the expansion happening. These tend to be smaller locations, but in more remote places where you wouldn't necessarily have easy access to a detention facility, they will enter into contracts so that if someone is apprehended in that vicinity, they have someone to take them to without having to take them many thousands of miles away. And then there are also a smaller number of U.S. Marshals facilities that are used that ICE enters into contracts with as well. I mentioned earlier that there are adults here in these facilities. Some have both men and women, not commingled, but both on site. Some are exclusively, just male. The vast majority of immigration detention is adult males, though there is an increasing number of females being taken into custody and held. But it's worth noting as well that there are families. So I mentioned that unaccompanied children are kept in separate shelters just for unaccompanied children, but there are family detention centers that Denise will talk more about, where mostly mothers, though not exclusively, are taken into custody with their children. They have generally been apprehended at the border, typically asylum seekers coming from Central America, but from other locations as well. And there are 3 family detention facilities, 2 in Texas and 1 in Pennsylvania. There are different standards that govern these different contracts and detention facilities. And they are worth noting because they govern the conditions under which these detainees are held. But it is important to note that they are non-binding. So for violations of these standards, it's been quite difficult to challenge or sue for violating those standards because they're non-enforceable. They're not regulatory, they're not statutory, they are non-binding standards that ICE has very intentionally not codified into regulation. Many of the county jails are under standards, they're called the National Detention Standards that were created in the year 2000, which are sort of bare minimum standards, whereas some other facilities are subjected to what's called the Performance-Based National Detention Standards, PBNDS, which was initially created in 2008, and then there was an updated version in 2011, which provide for improved conditions, issues related to access to telephone services, to interpreter services, medical care, sort of a range of issues. But so in this landscape of over 200 facilities, not only are there different types, but they're governed by different standards. There are inspections that we won't really have time to talk about today, though happy to answer any questions about them. The standards are what facilities are inspected against. So the weaker the standard, the weaker the conditions and the less to hold them accountable for. And a lot of these county jails will often either be doing self-inspections, which is not, so not an independent third party, or ICE is doing the inspections, and there's a self-interest in them passing those standards so they can continue to use those facilities. Finally, I do want to mention that there are a lot of issues around vulnerable populations that are being held in facilities, and we'll talk a bit more about, how individuals, may get released from custody. But there are different populations that fare differently in detention. In particular, LGBT detainees, for example, who statistically have experienced higher rates of assault, sexual assault and harassment, rape. They have different challenges related to being placed in solitary confinement or segregation, which even if it's for their own safety because they're not safe in general population, it means that they can be held in segregation for great lengths of time, much to the detriment of their mental health. There are also a lot of individuals who have mental health issues or other physical, medical issues that are not served well in a detention setting. I do want to note, to bring it home for a moment, that there are, for those of you not familiar, I wanted to flag the detention facilities that are in Michigan. There are others in the nearby region, but in Michigan, the primary detention facilities in use are the Calhoun County Correctional Center, which has an average detained population over last year of 169 individuals. I will note that that is one of the facilities that has a guaranteed minimum built into its contract. So they get reimbursed, the county jail gets reimbursed for 75 beds whether or not they get used. So it's no surprise that those beds are full, and then beyond some. The St. Clair County Jail and the Monroe County Jail are also used with different average detained populations, as you see above. Neither of these, sometimes even though these are county jails, some county jails can then subcontract out their services to private facilities, to private prison companies who then provide certain different security or meal services, medical services. These county jails do not contract out, so these are purely county run. I will flag that in October, there was a recent request, it's called an RFI, a government request for information about other new sites because they are looking to expand. It's not quite an RFP, this is the preliminary step before they actually solicit proposals, but they do note that they are looking for new sites within 180 miles of Detroit, Chicago, St. Paul, and Salt Lake, so something to watch for. I do want to flag one other big issue that is really tied closely with detention, and that is access to counsel. Because one of the biggest challenges of having people detained is providing them with legal representation. These are often in remote places, or they're difficult to access given the rules of that facility. And so overall, representation rates in the detention system are at 14%. So you may know, I hope you know that immigrants are not provided in like the criminal justice system. They have no right to appointed counsel. They're not provided government-funded counsel. And so it's up to private bar attorneys and NGOs and others to provide that counsel, and it's quite challenging to do that in the detention system. In the Detroit detained docket, the representation rates are a bit higher because it's closer to a metropolitan area, 24% in the Detroit area. I want to conclude by just noting some expected changes. I mentioned that we're expecting an expansion, or at least an effort to expand the detention system, which is largely up to Congress to fund those additional beds. But apart from the increase in the number of beds and where those beds may be, is a question of who ends up in those facilities. And as this indicates, a trend over time, the border apprehensions overall, since 2000, as you see above, have been dropping. There have been fluctuations, no doubt, but with border apprehensions historically being a very major driver and continue to the extent that they are, the apprehensions continue today, they will always be one of the main feeders into the ICE detention system. But when those numbers drop off, those beds will be filled by other people. And we do expect to see more people who get apprehended in the interior to be in those beds. And that means a few different things. First of all, with the change in enforcement priorities under this administration, different types of people are coming into ICE custody. So while they are looking supposedly for people just with criminal issues or old removal orders, they are also taking into custody collateral arrests, those they bump into along the way while they're looking for those other individuals. And that can include anyone who is out of status or they have reason to suspect is removable. That could include any one of the DACA beneficiaries who loses their status, or other individuals whose status unfolds who maybe in past years wouldn't be on the radar of ICE, but now will be. It could also include people who've been here for a very long time. So individuals who have and that's always been the case, but with increased numbers of people coming from the interior. We're talking about people who have lives here, who have children here, who may be breadwinners for their families, and that will impact who we see in custody. Finally, I will note that there are some of the facilities which have been used only for shorter periods of time, for 72 hours, which were really under the weakest standards, because the idea was we're not holding them there all that long. It may not matter how good the standards are. They'll get moved to another facility. ICE would like to, and I believe has begun, to shift them from 72-hour facilities to 7-day facilities. So they're being held in those facilities for longer periods of time. And what we'll see are more problems. We see more deaths in detention. As more people are kept in detention and kept under weaker standards, we will see more problems, more deaths, more illnesses, more suicides, more just problematic cases. So it's a pretty bleak landscape, unfortunately, but we will see as it evolves. You know, there are many plans in the works, but we'll see how they actually get implemented. So with that, I will turn it back to Rachel.
Okay. We're going to turn it over to Anil right now, and I will get out of our PowerPoint. Go ahead.
Great.
Thank you.
So thanks so much to everyone here at Wayne State for holding this event and for inviting me to be a part of it. Royce has given a really, really great overview, a very comprehensive overview of what the detention regime looks like and how it has evolved over time. I'm going to talk primarily about the legal framework that governs how detention decisions are made in the immigration system, including both the statutory framework for those decisions, and in many cases non-decisions, because Congress has sought to mandate detention categorically for a number of categories of people, as well as the constitutional limits and constraints on that statutory framework, along with how the Supreme Court and lower courts have been engaging that legal framework. Before I do that, just a couple of things to reiterate by way of background and context, some of what Royce just said. I think it's worth emphasizing how new this system is, right? So you can see the numbers really emerging from the 1980s. Between 1954 and the 1970s, there was almost no immigration detention really of consequence. And that's not because there has never been immigration detention in U.S. history. It's because in the 1950s, the Eisenhower administration made the self-conscious decision to undergo a fundamental shift in the nation's relatively long-standing immigration detention policies. They announced that the INS would no longer routinely detain people who were potentially excludable or deportable as a matter of course, but rather would initiate deportation proceedings by orders to show cause, and rather than just routinely arresting people, and that had a profound effect. The average number, there had been significant detention before 1954, an average of 4,000 per day, not on the level we have today, but and the total aggregate over that year was, in 1954 itself, I think, was about 500,000 people, but detention facilities closed, most notably Ellis Island. The number of individuals dropped sharply, but by 1958, the Supreme Court could say, in an opinion, that physical detention of aliens is now the exception, not the rule, and it is generally only employed as to people who are security risks or likely to abscond, and the overwhelming number of people who were still detained were for very short periods of time. By 1961, the average number of non-citizens in detention per day had fallen to 800 people. Right, from 4,000 to 800 people over a relatively short period of time, and the Supreme Court, in one of these opinions, announced this is the hallmarks of a humane and enlightened civilization, or words to that effect. So, I think we sort of, as we think about this conversation now, we sort of think sort of with a certain kind of inevitability. But we have had decarceration moments in our history before, and it's worth thinking. The regime doesn't look the same now, so it's not the same kind of challenge to engage that. But I think it's just worth remembering that and sort of putting that in the context of this discussion. Now, Royce also emphasized that immigration detention is a civil form of custody. Not a form of criminal punishment. And one implication of that is that the justifications as a constitutional matter are different. So to facilitate deportation or exclusion, which are themselves understood as civil sanctions, not a form of criminal punishment, detention and other forms of custody are constitutionally permissible for one of two purposes that have been recognized. One, to prevent individuals from fleeing and not appearing for immigration proceedings, or if they've been ordered removed, for the removal itself. And two, to prevent individuals from endangering public safety if they might pose a danger to public safety. Those are the only two purposes that have been constitutionally recognized as permissible for civil immigration detention. And if the circumstances of detention become excessive in relation to those purposes, then detention could be understood as punitive and not authorized under the not permissible under the Constitution. Now, in terms of how these decisions to detain get made, for most civil forms of detention, resting on similar kinds of rationales, the constitutionally favored approach is to have a determination of whether detention is necessary by an independent adjudicator. So in the immigration system, this would be an immigration judge in a bond hearing, making an individualized assessment as to that individual's flight risk or danger to public safety. But in the immigration context, one of the long-term trends since the 1980s and 90s, both from Congress but also in other ways from the immigration agency itself, has been to institute broad categorical mandates or presumptions for who should be detained, not based on their individual circumstances, but based on their inclusion within certain broadly defined categories. So, so under these kinds of provisions, and I'm going to speak about these at a relatively high level of generality rather than getting too far into the weeds of the statutes, but under these provisions, Congress has sought to mandate detention for virtually anybody who is inadmissible or deportable on crime-related grounds, which in the immigration context have come to include a really broad array of crimes that can render somebody deportable or inadmissible. To those who are inadmissible or deportable on the terrorism-related grounds, which were instituted in the 1990s and then have been sort of refined and enhanced since then, to most arriving non-citizens who are charged as inadmissible, including individuals who are subject to expedited removal, and to individuals who are awaiting the execution of final orders of removal after they have been ordered removed. Now, in the 1990s, after these provisions had been enacted, and they were enacted over a series of statutory, in a series of statutory enactments culminating in two major statutes in 1996, advocates sought to challenge two different aspects of this detention framework in particular that resulted in litigation that resulted in two major Supreme Court decisions that are somewhat in tension with each other, and that I think the tension between them continues to sort of be how, playing out in litigation today and in sort of how detention decisions are made. So one set of cases challenged a government practice of indefinitely detaining individuals who had received final orders of removal in their immigration proceedings, but who the government was not able to remove. So, for example, because the country of origin would, to which the United States was seeking to remove them would not accept the individual's return. These are individuals that people within the INS would refer to as lifers. So even though their removal was no longer reasonably likely or foreseeable, and in some cases was exceedingly unlikely at all, the INS would continue to detain a non-trivial number of these individuals. And in 2001, the Supreme Court in Zedvitas versus Davis held that the indefinite, potentially permanent detention of an individual who faced no reasonably foreseeable likelihood of removal raised serious constitutional questions under the Due Process Clause, and in light of those constitutional concerns, the court interpreted the relevant provisions in the Immigration Act not to authorize indefinite detention, but rather to require periodic review beginning after 6 months had passed. Now, strictly speaking, this is not a constitutional holding. It's a statutory holding in the shadow of these due process concerns. But much of the reasoning in the decision was in constitutional terms, resting on due process principles governing civil detention, with a pretty strong implication that if the court were forced to reach the constitutional questions, it would strike this regime down as violating the due process clause. As the court stated, a statute that would permit indefinite detention would raise a serious constitutional question, especially since one of the two legitimate purposes that had previously been recognized as permissible to authorize civil detention, preventing the risk of flight, becomes weak or non-existent when removal becomes a remote possibility for these categories of individuals, right? So at that point, detention might still be permissible to protect public safety. The court emphasized the need to limit that kind of preventive detention, particularly if it might be indefinite, to specially dangerous individuals along with some other special circumstance, if there's in addition to the danger, and in a regime that has strong procedural protections, because that's how other forms of civil detention operate and how they are understood to be constrained by the due process clause, whether it's civil commitment or the sex offender kinds of detention regimes, or for that matter, pretrial detention. So the court interpreted the relevant statutory provisions not to authorize continued detention once removal was no longer reasonably foreseeable, and then recognize this initial presumption of 6 months as a reasonable period of detention, which I think it's also worth noting. That is not the kind of presumption that would operate in other kinds of civil detention systems, right? That you'd have this sort of, that you could have detention for that long. But after that, if the non-citizen could provide a good reason to believe there was no significant likelihood of removal, then the government would have to respond with some evidence to show, to rebut that showing and show that in fact actually there was some likelihood of removal. And as detention became more prolonged over time, what would count as a reasonably foreseeable future would also diminish over time. So you couldn't in fact just sort of roll over people into these longer periods of detention sort of indefinitely. Now, that was in 2001, in the spring, before the 2001 terrorist attacks. The other detention issue that was being challenged at this time in relatively major litigation was under Section 236C of the INA, which categorically mandates detention for individuals based solely on their being inadmissible or deportable because of prior criminal convictions. No matter what the conviction, and again, there's a very wide array of convictions that can render somebody inadmissible or deportable. They could also be rather old convictions. And so just categorically based on this conviction, as opposed to an individualized assessment of the individual's risk of flight or danger by a neutral independent arbiter, this statutory provision purports to mandate detention. Now, unlike the individuals in Zedvitas, the individuals who are covered by this provision are not individuals who've been ordered removed yet. This is before they even have a final order of removal. So this is detention while their removal proceedings are pending and before a decision has been made. And in Demore versus Kim in 2003, less than 2 years after Zedvitas, the court sustained this provision against constitutional challenge, at least in circumstances, the court said, in which those individuals have conceded their removability, as Kim was understood to have done, the respondent in that case, and the period of detention was understood to be brief. And the court emphasized statistics that were presented to it by the Solicitor General about the length of detention for the people covered by this provision. And they emphasized that in 85% of the cases in which individuals were detained under this provision, removal proceedings were completed in an average period of 47 days and a median period of 30 days. And in the remaining 15% of cases in which there was an appeal, the average length of detention was 4 months. Now, Senator Levin emphasized the importance of facts. It turns out that the information that the Solicitor General presented to the Supreme Court, untested in litigation in the courts below, was wrong. and the periods of detention were quite a bit longer, which the government then acknowledged to the Supreme Court in a letter filing a couple of years ago in connection with the Jennings versus Rodriguez case, which I'll turn to in a moment. The periods were, in fact, much longer than what the court had understood to be the case, and in fact also Mr. Kim, the respondent in that case, had not conceded his removability. But this was what the court understood to be the case, and these were factual predicates, these were premises to the court's decision-making, that the respondent had conceded removability and that the periods of time for detention were relatively short. Now, Justice Kennedy issued a concurring opinion suggesting some limits on the court's holding that if continued detention became unreasonable or unjustified, particularly for a lawful permanent resident, that due process might require an individualized bond hearing, and if there were some unreasonable delay in pursuing or completing deportation proceedings, then the question might arise and need to be considered whether detention was not really serving its permissible purposes anymore, but might in fact be taking place for some other impermissible reason. But the effect of the decision, he joined the opinion, provided the fifth vote for the decision, was to sustain this provision against constitutional facial challenge. Now, these two decisions are in tension with each other because you have on the one hand Zedvitas providing, strongly suggesting from a due process perspective that an individualized assessment is necessary at some point, even for somebody after a final order of removal has been entered, if removal is not reasonably foreseeable. And then you have Demore versus Kim for somebody who doesn't even yet have a final order of removal, sustaining this categorical regime providing for detention. So in the years since then, there have been many individuals who have been in prolonged periods of detention as this regime has grown. This regime has grown simultaneously. Adjudication can be very slow. So there's a lot of people who are in detention for prolonged periods of time, even before their hearings even before there's a final order of removal. And in the lower courts have sort of struggled to, what do we do with these competing commands? On the one hand, when detention gets prolonged, it may raise constitutional concerns. On the other hand, the Supreme Court has upheld this categorical regime. Now, every lower court to consider the issue has found that the extreme position that there's no limit on the time period before a removal order, or for that matter, even after that's governed by Zedvitas. But for people who are governed by the provision that was at issue in Demore versus Kim, and the detention is becoming prolonged, what do you do with that? So the lower court started to see long periods of detention. So the Supreme Court now is considering a case, Jennings versus Rodriguez, originally granted in 2016, argued in 2016, but then held over for re-argument. That was an 8-justice court, so it was held over for re-argument before the 9-justice court, now that Justice Gorsuch has been assumed his seat on the court. So that's now been argued twice. That presents the question of prolonged detention. Is it permissible for individuals to be detained for prolonged periods of time without an individualized bond hearing before an immigration judge for 3 different subclasses of people? So you have people who are covered by this mandatory detention statute that was at issue in Kim, but not for the limited period of time where they've conceded removability. These are people who have substantial defenses against removal. So those are naturally people who take longer. Then you have a subclass of people who have arrived as non-citizens, who have arrived in the United States and are seeking to enter, and either are applying for asylum or are otherwise in removal proceedings upon arrival. Again, people who have defenses to removal. And then the third class of people are people who are detained under the general detention provision, which does allow for a bond hearing initially, but then in fact actually if the detention can still become prolonged if they're not released at that point, can they in fact then be released? The Ninth Circuit then certified this class. I mean, the district court certified this class, and the Ninth Circuit held that for people who are in prolonged detention, there is a constitutional requirement for a bond hearing. Actually, it interpreted the statute not to reach that constitutional question, not to authorize prolonged detention. So this is now before the Supreme Court. The lower court also set forth certain requirements for what those proceedings would look like, such that it's the government's burden to establish by clear and convincing evidence that the individual needs to be detained, not the individual's burden to establish that they are not that they're not a danger to safety or flight risk. These numbers are pretty significant in terms of the length of detention. I mean, the average length of detention for people in this class is 13 months. And this is a class of thousands of people. 20% of them are detained for more than 18 months, 10% for more than 2 years. For the arriving non-citizen subclass, 97% of them applied for asylum, and 2/3 of them had strong enough claims that they received asylum. And of course, people who are in detention for long periods of time, the ability to vindicate your, present your defense and prevail in your claim is harder. So this is now before the court, and I think one thing to emphasize, and maybe I'll just wrap up with this, is that there's a long-standing, as I'm sure many of you know, understanding from a constitutional perspective that in the immigration context, the rules that apply to immigrants are not the rules that apply to other individuals in comparable circumstances. And this is not the kind of detention regime that the Supreme Court has typically tolerated with respect to any other kind of civil detention system in terms of what kind of, dispensing with some of the constitutional standards that would apply. And so I think that's just something to think about. There's long been a critique of those premises, and we've seen in other litigation emerging this in the course of the past year, whether it be the Muslim ban or some of the other issues, that some of those questions are on the table. And I think it'll be interesting to see in the context of the Rodriguez case whether the Supreme Court sort of pushes in that direction even further or reinforces some of those premises.
Thank you very much. I'm going to turn over the floor to Denise now.
Thank you, and thank you so much for this opportunity to be here today, to the Wayne Law School and to Senator Levin. It really is a wonderful opportunity to share this dialogue with colleagues this morning and throughout the day, and particularly to have the opportunity to speak on immigration detention, which is, you could call it an intellectual passion, or you could call it an obsession of mine to think and work on these issues, both in terms of my research and writing, as well as in the practice that I do through the immigration clinic at UT Law School with my students. And in fact, I'm going to start there with a story of a client that we are currently representing right at this moment, to put some of this into context of what it really looks like on the ground. So we are representing a woman, an indigenous woman from Guatemala, from a tiny rural hamlet in the mountains of Guatemala, very remote. She barely speaks Spanish. She speaks very limited Spanish. She speaks an indigenous language. She's been held at this facility, the Hutto facility, which is about 45 minutes outside of Austin, which holds about 500 women, mostly from Central America, mostly asylum seekers. This is what it looks like on the inside. It was previously a medium security prison. Those are cells that are around a pod where the asylum-seeking women are held. They eat, go to the bathroom, sleep, all in this pod. It has been painted with pretty colors because for a while Hutto was a family detention center where children and adults were held. Now it holds only women. So in the scheme of things, some of the conditions here are actually a little bit better than some other detention centers, but it is still very much undoubtedly a jail where asylum seekers are being held. As I say, she's been there for 4 months now while she pursues her claim. She has no ability to get out of detention under the scheme that Anil just mentioned, because she originally came to the United States last fall seeking protection and was immediately turned away at the border and sent home. And so then when she went back and experienced more abuse, she came back to the United States this summer. And so she had this old deportation order against her, which means that even though she then passed a screening interview saying that she has a viable refugee-related claim, she is being held as though she has a final order of deportation, so she has no opportunity to get out through an ICE custody determination and no opportunity to go for that immigration court review of her detention. Her case is based on the fact that she suffered almost 20 years of extreme domestic violence. And for those of you who don't know, domestic violence is actually a very well-recognized asylum claim in the United States. And in fact, the precedent decision on this is almost exactly like her case. It's a case from Guatemala involving a woman who was married to an abuser. In this case, our client is in fact actually married, which is relatively uncommon, to her abuser, and experienced 20 years of beatings, rapes, verbal abuse, and the rest. And she was largely entrapped in her home. And I mentioned that because she is now held in a detention center where those experiences of entrapment and trauma are really worsened. And in the United States, we have great experience now with victims of trauma, and particularly gender-based violence in other contexts. Yet in the immigration context, we see it fit to detain in a jail-like facility similar survivors of domestic violence. In the facility, nobody else speaks her language, not even other women in the facility, much less the guards, so she cannot communicate with anybody in her native language, which is deeply isolating. And her hearings are taking place in a room, and I am not exaggerating, that is the size of this table. In fact, she is represented by my clinic, and the way my clinic works is that normally I go with 2 student attorneys to represent our clients. However, we are not allowed, the 3 of us and our client, into this room because it is simply too small. So we have to choose which of her legal representatives will accompany her to her hearings in this room. The hearings, of course, are conducted by video. So the room contains a television screen right here where the hearings take place. For some months, the hearings were being conducted, even though we were near Austin, Texas, the hearings were being conducted by the Miami Immigration Court. And so we were not even in the same time zone as the judge who was hearing the case. And we were in this closet while the trial attorneys, the government attorneys prosecuting the case, were sitting in the courtroom with direct access to the judge, with access to their laptops and their phones. None of this is allowed. None of this technology is allowed anywhere inside the detention center at all. Then the case got transferred back from the Miami Immigration Court to the San Antonio Immigration Court, which is closer physically. So now probably we will be separated from our client. She will sit in the closet and have video hearings, and we will sit with the judge in the San Antonio Immigration Court, which of course presents its own problems. But right now, we don't have any hearing date set at all. It's been 3 weeks since we last had any notice of a future hearing date. So currently she's sitting in immigration detention, purportedly in connection with removal proceedings. As has been pointed out, that would be the only justification for her detention, yet she has no removal proceedings taking place at all. No hearing date set at this time. When we meet with her at the detention center, we meet in a visitation room that is set up with 3 or 4 plastic cubicles that are neither visually providing of confidentiality nor auditory confidentiality is available to us. And these are the circumstances in which asylum seekers and others are held during their removal proceedings. I think if there's one takeaway that I'd really like to convey at the beginning, as I then delve in a little bit deeper to some of the realities of how detention is playing out, is that both ROYCE and ANIL really expressed how this is a civil detention system such that detention must be justified based on the connection with the removal proceedings and the idea that there would be a flight risk or a danger to the community if an individual were released during their ongoing removal proceedings, which might result in deportation, but to be clear, which might result in permanent ability to remain in the United States as a refugee or under other forms of relief that are available to people in detention. So that the detention has to be justified. Yet I think there really is sufficient evidence to suggest that detention levels, particularly at the current levels of 40,000 a day, 400,000 a year, much less at potential expanded levels of detention, really cannot be justified by these considerations of flight risk or danger to the community. It just simply isn't the case that there are 40,000 immigrants each day who present a significant flight risk or danger to the community such that they must remain in detention, much less 80,000 individuals a day. So what is driving detention? I would assert that it is in part money. This is a very financially lucrative process at all levels, and I'll talk more about that. And it is also driven by symbolic politics, by the need to show get tough on immigrants' actions, with detention being a relatively simple way to do that. I would argue that it's not even really determined by legal provisions, although, as Anil especially highlighted, there are these mandatory detention provisions that explain some of the levels of detention. But if you look at the numbers, and they are opaque to get data from DHS, only about half of the pre-trial people waiting for a decision in their removal proceedings of the detention population is in the mandatory detention category. So there are a number of other issues going on as well that I'll get into. And in fact, I'll go there. So let me first show you just a couple of other detention centers. These are in Texas so that you can get a sense of what some of them look like and the jail-like conditions of the facilities. Now where I'd like to go is to talk a little bit about what is happening with those individuals who are not in these categories of detention that are either mandatory by congressional determination, that's really the folks with some criminal history, or they're also not in the categories of individuals who are not congressionally mandated to be detained under that statutory provision, but who are nonetheless being interpreted not to have immigration court review of custody. That's a slightly separate issue, and those folks are, for example, individuals like my client who's currently at Hutto, who has no review of her custody by the immigration court because she's deemed to have a final order behind her, a final order of deportation. And it also applies that lack of review to individuals who are presenting at the border. Even those who present at the border, knock at the door and say they need asylum. Those folks don't have review. And there has been a lot of attention paid to those categories of individuals who are either in mandatory detention or who have no access to review. And that is very important. But as I say, it's also important to look at those who do have, in theory at least, the right to individualized determinations regarding custody and review. And so I want to focus a little bit on those individuals and explain why even there we're not actually seeing that those who are detained are those who most need to be detained, where there is adequate justification. So I want to explain that there are really two stages to the custody determination process. We've kind of alluded to this, but just to make it clear. So for people who are eligible for release, who don't fall into any of these more categorical categories, first, ICE makes a custody determination, and ICE can either release on a recognizance without any bond paid, or it can set a bond, or it can insist on continued detention. Release on recognizance is very rare. So basically nobody just gets released, even though, as we've pointed out, civil detention is intended constitutionally to be the exception rather than the rule. release on bond is not really release, because release on bond necessarily means that you are being detained for at least some additional period while you gather that bond and get out of detention. Okay, so it is very rare that people just get released on the theory that there is not sufficient grounds to hold them. They may get a bond set, and then in some cases ICE determines that there will be no release at all. For those who get immigration court review of their custody, that would be the second step. In the immigration court as well, release on recognizance is extremely rare, and essentially what the immigration court does is do a review of any bond amount set by ICE. If ICE has issued a no-release decision, then the immigration court may instead say, well, actually, I think that we can release this individual on bond. But money bond becomes really the central characteristic that determines whether or not, in fact, somebody will be released, even where either ICE or the immigration court has said, yes, this individual can be released, but they need to pay a monetary bond. And in many cases, individuals simply cannot pay the bond amounts that are set, either by ICE or the immigration court, and so they remain in detention, not because of any determination of flight risk or danger to the community, but because they are poor. And this is the reason that in the criminal justice system, there has been a huge movement away, imperfect, not all the way resolved, but a huge movement away from monetary bond as the primary lever of detention and release. And there has been a strong move towards a recognition that where there are actual risks presented in a particular case, then there should be conditions of release that actually address those risks. So, for example, drug testing, or reporting requirements, or sometimes assistance with housing or with employment to ensure that people have the conditions in place that will allow them to appear for their future hearings. But recognizing that bond, neither monetary bond, neither effectively promotes appearances at hearings, nor really ensures that those who present the greatest flight risk or danger are the ones who remain in detention, since wealth is what ends up determining who stays in detention rather than level of risk. In the immigration context, I would argue that the reliance on bond is even more problematic than it has been in the criminal justice context, because given the sort of exceptionalist nature in which we tend to treat immigration detention and the lack of critical oversight up to this point, you can't really say that even the bond decisions are truly individualized with adequate review. So typically what happens when ICE makes its bond determination is that it makes across-the-board determinations, even where you're not talking about mandatory detention categories, still the bond amounts are set at categorical levels that don't really look at individualized circumstances. ICE has a risk classification assessment tool that it claims to use to assess risk. However, the limited studies that have been conducted on that, given the unavailability of data, suggest that that tool essentially just always recommends detention, and so provides very little usefulness in terms of actually individualized custody setting. So this graph is based on data that I obtained through FOIA litigation from the Department of Homeland Security, just for sort of bonds and custody decisions just at the Hutto Detention Center for a 6-month period under the prior administration. And what you see here is essentially that for any particular period of time, bonds are set almost all at exactly the same level. You see 7,500 for a month or two, then all of a sudden they drop to 3,000 across the board. For a little while at Hutto, there was even OR, people being released without any bond, and then it went back up again. But what you don't see is much in terms of individualized determination. So what dictates why those bond levels are set categorically but at varying amounts? I would argue, and I think there really is evidence for this, that it's mostly about detention bed space, as Royce mentioned, and the idea that we have these detention beds, so we need to keep them full. And the private prisons that are managing these facilities have strong interest in making sure that those detention beds are full in order to continue to promote the existence of the existing detention facilities and the expansion into additional detention facilities to increase their profits. And so what happens is that by setting bond levels at different rates, you can manage the length of detention. And so it's kind of common sense, but the data bears it out, that the higher the bond amount is set, the longer an individual remains in detention, quite clearly. And so what actually happens is that when there are larger numbers of individuals being booked into the facility, the bond levels can go down because there's sufficient turnover to keep the beds full every single day, regardless of whether or not there's a need to detain, but you can keep the beds full with relatively short times in detention. But when bookends go down, then you have to extend the length of detention in order to keep the same number of beds full. And so what ICE will often do in its determinations is increase the bond level across the board. And we've seen this up and down cycle at the facilities where I work over time repeatedly, including, this is sort of from the 2013-2014 period, but we certainly saw it again just this year. At the beginning of the year, at the beginning of the Trump administration, ICE was actually setting no bond, continued detention, and then eventually setting very high bonds. And then by the summer, when the numbers of Central American asylum seekers again increased at the border and bookends were up, we started seeing the bonds go down, and currently they're at about $1,500 bonds at the ICE level in order to get people through the system more quickly so that new people can come in. And the average daily population at HUDO has remained almost completely consistent over the years through these mechanisms. And this should be, I think, deeply disturbing, because it really does establish that decisions about whether somebody is going to be deprived of their liberty do not depend on their individual circumstances or on the need of the government to detain them, but on bed space, which is, as I say, largely driven by the private prisons, which wish to keep those beds full. And you can sort of see this. I used to have some doubts about this connection between private prisons and detention, and I don't think it's the only explanation for the incremental and vast expansion of detention, but there's definitely a connection here. This chart shows the increase in lobbying dollars and campaign contributions together with the increase in detention beds. And, Senator Levin introduced us this morning in talking about the importance of democratic governance and rule of law. And I think here both of those values are in real question when you see this kind of distortion of good policy making around keeping detention levels at a place where our dollars, our taxpayer dollars, are being used appropriately, and where we're only depriving those of liberty who actually need to be deprived of liberty. And real questions about the rule of law, given the example I just described to you of what it's like to try to engage due process from within a detention facility. Now, I want to be clear that ICE also has certain sort of economic incentives around the bond setting process. They've made very clear in some of their materials on bond that they get to keep breached bonds, and so there's an incentive in where they can to set bonds relatively high in the hopes that at least some of those will be breached, and that money will then feed back into the detention system. So essentially somebody in detention today who pays a bond to get out is funding the detention in part of the next person in the system. And so I think another thing to keep in mind is even in today's times sort of less concern perhaps about economic inequality. There is a real concern with money being made off of the backs of the vulnerable and poor, and I really do think that both through the way the government funds the system and the role of private prisons, that this is a pretty clear example of it. I should probably start ending, but I did want to at least mention how this all plays out in the family detention context. These are a couple of images of the two very large family detention centers, moms and kids only, in Texas. One is in a small town called Dilley, Texas. This is this one. It's run by CoreCivic now, then Corrections Corporation of America. And the other one is in Karnes City, Texas, another very rural community. This is where they marked out the part where it said detention center, and now it says family residential center. They're both jail-like facilities. This one's run by GEO. And really what happened here is that when the crisis came up in 2014, where the press was suggesting that there were very large numbers crossing the border, even though, as Royce pointed out, overall border crossings were still at historic lows, but there were increased numbers of women and children crossing the border from Central America, and this became a very significant issue in the press. The government kind of became concerned about what to do, and CCA and GEO offered a solution which looked much like what they had done in every other immigration detention context, which was to set up prisons, in this case for women and children. And shortly after these facilities were opened in the fall of 2014, CCA and GEO mentioned that they had and announced to their shareholders that they had created very significant new profit centers. And then it became this cycle. Once the facilities were up, GEO and CCA really pushed against litigation that would have limited the detention of mothers and children in these facilities, and engaged in a number of strategies to ensure that they could continue to run these facilities to ensure their profit motive, including, for example, by seeking to obtain child care licenses through the state of Texas for the Karnes and Dilley facilities, even though there was absolutely no provision for child care licensing of jails in the state. And in fact, the family detention example also demonstrates another phenomenon, which is that when there is any sort of curbing of immigration detention, the role of private prisons comes back into force, and they seek out other ways to ensure some form of continued profit. And so when we succeeded in some litigation around family detention, there was significant pushback by the two private prison companies involved, but also they sold sort of another kind of tool to the administration in the form of electronic ankle monitors, which are also really pulled from the criminal justice system, but now applied in immigration detention. So now times of detention for families at Karnes and Dilley are much shorter, but when families are released, the women are placed on an electronic ankle monitor, essentially across the board, again, without any real determination regarding flight risk or danger to the community. Today I've mostly focused on detention of asylum seekers because that's a lot of what we see in the facilities near me in Texas. However, I will note that those levels of detention of asylum seekers are increasing, have been increasing, and are staying at very high levels, and now we are seeing layered on top the interior enforcement situation, including a group of clients that we have, 3 young men who are construction workers who have absolutely no criminal history, who've lived in this country for many years, and who were picked up in a traffic stop where they were not even ticketed, and then sent to immigration detention and put into deportation proceedings. So that is the new reality that we're seeing on top of this pre-existing scenario. And I'll leave it at that.
All right. So I would like to take a couple of moments. We started a little bit late, so I'd like to take a few moments to open up the questions to the floor. So does anybody have a question for our panelists? Yes.
I think perhaps Professor KALHAN could answer this. I know with some jurisdictions like New York, since you have connection to New York immigration law, San Francisco, it's maybe 100% representation versus the statistic for Detroit was 24% or 14%.
24 in Detroit.
How did New York do it, if you know? I know there's sometimes a private and public venture to pay immigration attorneys or to pay for the representation. And a New York District Court judge success when those mentioned are represented is 8% higher than those who are not represented. So how did New York do it? If Detroit or
Do I need to repeat the question? Okay. If Detroit or Michigan were to institute such a public-private venture, what advice or suggestions do you have to increase? I mean, that's a vast difference in representation. New York and San Francisco may have 100% of persons represented versus 25% in this area.
Yeah, so I can give an answer in general terms, and there may be others who actually have more knowledge of this. So the story in New York is a really interesting one, because I think the catalyst for that was that the chief judge for the U.S. Court of Appeals for the Second Circuit, Robert Katzman, just very individually became alarmed at what he was seeing as the flood of immigration cases was coming into the Second Circuit. And so he convened what has become referred to as the Katzman Study Group, bringing together a whole range of stakeholders to think creatively about how do you address this representation crisis. And you know, that was a very long-term effort. I mean, as these things go, I mean, a number of years of conversations of just sort of thinking through how do you, in fact, get all these stakeholders to be invested in the solution. So that's how these private and public entities, I think, came together. And I'm speaking in very general terms because I'm not intimately familiar with every piece of it. There is a big component of this that is the New York City Council, you know, leadership of the speaker, especially Melissa Mark Viverito, sort of making this, championing this issue. So to bring sort of public funding to bear. And then a variety of other projects and you know, other outside, you know, the bar foundations sort of coming to fund other pieces of it. But there may be others who actually could speak to more specifics, and I can certainly connect you to people who have been very intimately involved as well.
Okay, I do have, oh, sorry, yes. Go ahead, Susan.
Thank you. I did have a question, and then I also want to lift up Washtenaw County, which is the only municipal government that has put dollars in Michigan toward immigration defense, and we're very proud to have received that grant at the Michigan Immigrant Rights Center, and we have a full-time staff attorney serving Washtenaw residents with a variety of immigration legal matters, including detained representation. So I really want to lift up County Commissioner Conan Smith, who led that effort in Washtenaw County. But the question I have is that we, in the last few weeks, we do legal screenings for children in short-term detention programs in Michigan through the short-term foster care programs, and suddenly almost all of the children we're getting actually did enter the U.S. with a parent, and we can't figure out how that is compliant with the law, and of course we can't communicate with the parents in detention, who are still in detention at the border, so it's impossible to communicate with them. And I would just love any thoughts about what might be going on and how to address it. So we're seeing some of that in Texas as well. I mean, I'm mostly seeing the moms at Hutto, and you've got the kids here, and this is a less splashy but very real fulfillment of the President Trump's promise to separate moms and kids. And we are seeing it, not across the board, not in huge numbers, but we are definitely seeing that, and it's kind of happening in two ways. One is that sometimes the moms are being criminally prosecuted for entry or re-entry, and so the justification is that well, they're in the criminal justice system, so now child has to be treated as unaccompanied and sent over to the ORR shelter system. Or sometimes we're just seeing, I just spoke to a woman at Hutto the other day who was like our client. She's not a client, but who had a prior deportation order and came back. And so they're considering that she's subject to mandatory detention for removal purposes, and the child was on a first-time entry, and so they separated them on that basis. There is intense interest, of course, in learning about those cases, so I would love to make contact, and the Women's Refugee Commission is looking at this issue, and others are as well. Probably most of the actual separations happened in Texas, so one thing we're looking at, in addition to federal law, which there's a very clear definition of unaccompanied, and it doesn't mean people that the federal government has made unaccompanied by separation, through separation. But also, I think we have a state law argument that, of course, there is a child protective services system in the state of Texas that has very specific requirements, including appointment of a lawyer before you can remove a child from parental custody.
I do have a question. So about a year ago, there was a lot of talk in the media about how many people failed to show up for their immigration court hearings. And the number that kept getting thrown around was 90, 91%, where in fact, Department of Homeland Security statistics show that that is significantly lower, that approximately 20% of adults and 15% of kids fail to show up for their immigration court hearings, and they're heard in absentia. But one of the arguments for increased detention is to try to capture that number of individuals to make sure that they show up for their immigration court hearings. And I was wondering if one of you could speak to that concern.
I can take a beginning start at that. I do think that the reporting on an absentia rates are, the absentia rates are a little hard to dissect. Because if somebody fails to appear at their court proceeding and the judge does not continue the case and does go ahead and order them removed in absentia, that case ends very quickly. And so the cases that you're seeing, it skews the statistics, because the ones that are taking more time, where someone has appeared, where they need an additional time, you know, just because it takes long to calendar, but additional time to prepare their case, to find an attorney, especially since one's not provided, those will take time, and those are still working their ways through the system. And so it's inevitably those statistics are front-loaded with the cases that are ending faster because they're not appearing. So it's not to suggest that if you took a group of people and watch them all, it really, you have to do more of a longevity study, frankly, because the courts are so backlogged that the ones that are appearing are not completed yet. And so you can't, it's like an apples and oranges comparison. I do want to note, in terms of there are a lot of ways to ensure appearance at a proceeding without detaining someone, which is maybe the larger point here. What individuals often, I mean, the immigration court system and the detention system are so complex that for individuals who may, I mean, for trained lawyers who are native English speakers who've worked in immigration, they are baffled by the system oftentimes. So let's start there. Now let's talk to the average either, you know, child or family or adult who has no understanding of our system, doesn't speak English. There's very limited information provided to individuals upon release about what their obligations are. That's first. Second, the obligations are multifold. So they may be told that they have to appear, they have to show up at an ICE office, let's say in a week's time or 2 weeks' time or a month's time, to check in. And they don't necessarily distinguish that from a separate appointment to be at a court. They think they've fulfilled their obligations by appearing at the ICE office and don't understand that there is a tandem obligation to appear at court, because there's no, to an outsider, that's a very subtle distinction. They may indeed continue appearing at check-ins, but be missing court hearings because the systems are distinct and don't communicate with one another. So there There have been, through the family case management program that was started to assist families, it was a pilot program initiated to basically orient people to ensure that they understand their obligations and that they are settled. So Denise mentioned, so that they have housing. Not that they're paying for housing necessarily, but they're helping them find housing. Shelter care, or identify other programs that will assist them, faith-based programs, to make sure that people aren't failing to appear because they didn't have a home there and they had to go somewhere else where they could be, and they didn't know how to change their venue or their address with the court system. So there's so many pieces of this puzzle, but we have to make sure we're setting people up for success.
The only thing I would add, well, maybe two quick things, are that the studies show that you get extremely high appearance rates where you have counsel. And that's a function largely of what Royce is talking about in terms of the confusion regarding the process and the lack of information, a bunch of documents shoved at an individual when they're released from detention in English with no real explanation. So if you have an attorney, you're much more likely to be oriented to the process, and you're able to participate in the process meaningfully so that you're not quite as alienated and fearful, frankly, of what will happen in the process as well. And so, of course, one way in which we could ensure higher appearance rates without detention is by assigning counsel. And there are a range of ways that we could do that. It wouldn't have to necessarily be a completely federally funded sort of defender system, although that's a possibility. You could create networks like the one that you're describing here locally, combined with some federal funding, combined with NGOs. But if there were a way to ensure that every single person was represented by counsel, that would be a very quick way to drive up appearance rates. Would it be expensive? It absolutely would be. But remember what Royce mentioned about what it costs to detain somebody at least over $100 a day. So it would be cheaper than that by far. The second thing is that, as I mentioned, in the criminal justice system, there has been really sort of decades, literally, of work looking at how you get those appearance rates up outside of detention and without use of monetary bonds. And yet none of that, we borrowed the detention system and the bond system from the criminal justice system, but we didn't take any of the wisdom from the criminal justice system, and there is some. And you know what one of the things is that works most effectively for assuring appearance rates? A phone call, reminding people of a hearing date. We do nothing like that in the immigration system, and that has essentially no cost and could be done, and it really leads you to wonder whether the real goal is to get appearance rates high, or if the goal is just sort of an expediency of issuing as many orders as possible, even if that means that people haven't fully participated in the process.
The only thing that I would add is that one interesting thing about the Rodriguez case in the Ninth Circuit that's currently before the Supreme Court is that the lower court the injunction expressly requires the government, in making the determination as to whether detention is necessary, expressly requires them to consider whether alternatives to detention would suffice.
Are we done? Do we have time for one more question? I think we have time for one more question. Do we have any? I think.
First one to Ms. Gilman. If the number of cases motivate or drive the detention facilities to process more cases, why not just stop when the facilities are already full? What drives them after that to keep processing more quickly if they're getting paid for the same amount of beds being filled? I mean, why not just leave them there?
I see what you're saying, yeah.
Right. And the second question, just to the panel, can a governor's decision to pardon some of the crimes affect ISIS's decision to go ahead and detain a person accused of a crime or convicted of a crime anyway? Does the governor's finding have any effect on ICE's decision whether to go ahead and process.
So on sort of the question of why don't they just detain everybody for sort of indefinite periods of time, and that way you keep the beds full always without really having to kind of manage length of detention. I think there are a couple of things. First of all, I think that there is a political component to this, of course. It's not purely just sort of keeping beds full. And I think there would be concern from many policymakers on a political level of allowing people, for example, to cross the border and not be detained. So when you do have large numbers of border crossers and your detention centers are full, you have to either build a new detention center, which is the current sort of goal, or you have to release some folks so that the new folks can go in. Otherwise, the only alternative would be to not detain people in the interior or not to detain people as they cross the border, and I think that's politically challenging. The second thing is that there are some limits on detention, right, as Anil suggested, and so you could go for a system that just takes whatever population you've got and just hold them sort of indefinitely or at least throughout their case, which would generally take months or years. Then I think you would run into litigation around the constitutional parameters, so that there is, there is some limit on the government's ability. They need to almost for litigation position purposes to at least have some ability to assert individualized determinations for those who aren't in mandatory detention and a limit on the length of detention. In terms of governmental pardons, is the question like if you're committed of a crime and then you have a gubernatorial pardon, would that still count as a crime for purposes of detention and deportation? I think the answer is no.
I think it depends. I mean,
Yeah.
if the pardon or expungement is for rehabilitative purposes, that typically will not count. If it's a more fundamental, if the basis is more fundamental, it can, but that will really depend on the basis of it.
All right, well, I think we're out of time, so please join me in giving a big round of applause to our excellent panelists. Thank you very, very much. That was excellent. Thank you. And I know we didn't get to all questions, but the panelists will be here for a while, so please feel free to come chat with them.